Can you all hear me?
Yes, Judge.
Yes, Judge.
Yes, Your Honor.
Okay. So we're here for bond review.
Yes, Your Honor. We're able to speak with Miss Welch. I know she was trying to get into the meeting as well, but just to give you update, Your Honor, at this point, the defendant will be able to be admitted into the Chicago Behavioral Hospital for a walk-in evaluation. There is a Annabelle there who's expecting the defendant, and she understands what kind of sort of treatment he would need. I'm sorry, Your Honor. I'm skimming the email to provide Your Honor with the appropriate information. He does need to be evaluated and placed into this inpatient treatment until he's deemed safe. With that said, in speaking with Ms. Welch, if the defendant were to receive a recognizance bond, his grandmother would be able to take him to this Chicago Behavioral Hospital as soon as he was released from the jail. Should the defendant agree to do just that, go to this facility, at that point, he would then be able to receive the treatment he would need, and his grandmother would provide him the transportation to that hospital. I see Miss Welch has joined, so if I've missed anything, Miss Welch, please jump in.
Okay.
You said he would be admitted for a walk-in evaluation. So he's not being admitted, he's going there for an evaluation, and then they would decide whether or not to admit him. Is that correct?
Correct. How she explained it, because I explained the situation a little more in detail. She said they can't 100% guarantee they would take him for inpatient, but from what it sounds like, from what I told her they would need to do the full hour intake. She did mention that if you want more of a guarantee to take for inpatient, she said you could ask the judge to have a court-ordered petition stating that for inpatient treatment, pretty much stating that the client needs to be evaluated for inpatient and then not released until he is deemed safe. And she said that would pretty much guarantee they would take him. And it would be a short-term stay, but it sounds like they have options with his insurance that he has for like possible longer-term group home type care.
I'm not aware of any authority I would have to issue such an order.
I was confused as well. She said she's had it before where the judge has a court-ordered petition and that the client walks in with it. They just like it where the client walks in on their own for the eval.
They might have a petition to commit somebody for 72 hours for an evaluation and recommendations, but we don't have that here. This is...
I thought so. I did tell her, like, she has me to use as, excuse me, a collateral and grandmother. And she pretty much said with the information I'd given her, she believes they would take him for inpatient. It just can't be 100% guaranteed.
So if he was to be released and went for the evaluation, they were willing to admit him, but he wasn't willing to to participate in any treatment, they would want to release him, the same as the other hospital did a couple of weeks ago. Is that correct?
Correct. The other hospital, they did admit him and he was willing to stay. He just wasn't willing to follow through with some of the resources they were trying to provide him with afterwards. But yeah, so he would have to be 100% willing to complete the program.
Well, I was told the last hospital he wasn't willing to cooperate with treatment, but apparently that wasn't the case.
Well, he was taken there through Vista. I don't believe he had much of a choice at that point to go do the inpatient part. And then he started to comply with them. It was when it was time to set up an aftercare discharge plan. He refused any further treatment. He didn't want to take the medications they were asking him to take by injection, that type of stuff. He did follow through as far as staying an inpatient.
Well, I wasn't told that they wanted to discharge him. I was told, or at least it was implied, implied that they were about to release him because they didn't have a choice and they felt that he should stay. But apparently that wasn't the case. Mr. Wilson, have you had an opportunity to speak with your client?
I did, Judge, this morning, and he is indicated to me that he is willing to go to the Chicago Behavioral Health Facility. I explained to him that they would be then working on getting him into a group home located in Evanston, and that he can obviously still remain in contact with our social worker to help him in any way that she can through this process.
Well, yesterday we had a PTR hearing, and it resulted in the court ordering that the defendant remand so that options as to where he could stay could be examined, and anticipating he would be released today. And the court specifically asked the defendant whether he wanted to walk over to the jail or whether he wanted someone to come and get him. And he wanted someone to come to the law library and get him. And my information is that there was quite an incident that endangered the public safety when they tried to take him into custody. So I don't find I'm being told that both sides agree to a recognizance bond so he can go to this hospital and be evaluated, and he's willing to do that. But I have no reason to believe that that is in fact the case. So the motion to convert the recognizance, the cash bond to a recognizance bond is denied. Now, I show that the defendant, so the question is, since there was a petition to revoke, the petition, I'm talking about the most recent one, not the one from last week, that since the petition to revoke was granted based on the defendant's refusal to cooperate with his probation officer in terms of receiving treatment, report to probation as directed, defendant, failed to report to his probation officer within 24 hours of his release from the county jail. The defendant failed to reside at the address provided to probation and failed to update probation of any change in address. So the violations are paragraph 6 and 7. And we need to schedule a sentencing hearing. We can do that now, or if the defendant would prefer, do it on a different date. But the motion to amend bond is denied.
Understood, Judge. Is there an ability for Mr. Wilson to contact his client so we can determine if we'll move to sentencing today or at another date?
I can try and call over there now, or if we want to put it over to 1:30, I'll certainly have an opportunity to talk to him before then.
Judge, if it works, we can mute on my end, and his lawyer can mute, and he can call to a phone that's down here. If you are wanting to handle it now, Judge.
Well, I'm willing to do it. I just don't know whether the defendant and his counsel want additional time to talk, other than just a few minutes now. But if you want to go ahead that way, Mr. Wilson, why don't we start with that? And then if you'd like more time to speak with your client or to decide your position as to sentencing, we can always continue it to 1:30 then. So to the jailer, if you'd make that phone number available to Mr. Wilson.
It will be 4101. 4102.
I don't know, that one's 4105.
So I've muted everyone so that the discussion that Mr. Wilson has with his client won't be in anyone's hearing.
The phone number is 4103.
Very good. Thank you, Judge. I will give a call over there and see if we can't get this resolved this morning.
Okay.
Thank you, Your Honor. I appreciate that. Um, After speaking with Mr. Vincent and my client, I believe we have an agreement on sentencing for 90 days, which would be good time. So 45 actual, less the 7 days that Mr. Malicio has already spent in custody.
Well, actually, he spent 12 days in custody. The jail's number is incorrect. So 33 days remaining. I'd be willing, I would suggest that part of the negotiation would be that he have credit for any inpatient treatment days. Has he had any of those?
As to the inpatient, I don't know if that would, Ms. Welch, I don't know if he was actually inpatient at that previous hospital. I think you could expound more on that.
I believe the River Edge would be considered inpatient.
How many days was he there?
Ooh, you want to give me 1 second? I have his file, but I don't, oh wait, what did I do? I have to double check because I'm on a different computer, not my own, that's logged into RCE with the dates. But I
You
can
know
log in here.
How many days we're talking about?
I want to say it was maybe like 2 weeks worth, but I think it was about 2 weeks worth.
Okay, so would the state agree then that to make an offer of credit for time served, which is 12 days, and credit for 10 days for inpatient treatment?
I would agree to that, Your Honor.
And is that acceptable, Mr. Wilson?
Yes, Judge.
Okay. Did your, Mr. Malicio, did you want to say anything before I sentence you?
Judge, I appreciate this court.
Well, that's very generous of you, sir. I appreciate what you have to say. So the sentencing on the PTR is as follows. Defendants to serve 90 days with good time credit, and he's to have credit for 12 days previously served in jail and 10 days served in an inpatient treatment program. Will enter judgment on any outstanding fines or costs. The restitution will remain as restitution, but I understand the defendant's not in a position to pay that at this time. I would hope that if the victim is out-of-pocket money, that the state could direct those people as to how to apply for the state of Illinois program that attempts to make victims whole when there's a monetary injury. So, Mr. Malicio, this is an agreed sentence, but if you would like to challenge it or appeal or file a motion to reconsider, you're entitled to do that. If you want to do that, the public defender's office would be appointed to handle the paperwork for you. If you were successful, we would have another hearing. If we weren't, you would have the ability to appeal at no cost to yourself. Is there anything else you want to say, Mr. Malicio?
No, Judge.
Do you have any questions for me?
No.
Best of luck to you, sir. Okay, thank you all. No objection by anyone to end the meeting?
No, Your Honor. Thank you.
No, Judge.
Thank you, Judge.
Thank you.
Thank you, Your Honor.